As we begin the discussion today, I think it's safe to say everyone here on the dais, and I'm sure everyone in the audience, appreciates that the goal for the Great Bay Estuary is, in fact, to make it cleaner than it is today and to make it clean enough for habitat, including plant life, to flourish. Having said that, there will be multiple views, having reviewed the written statements, multiple views on how to achieve and to what level. And ultimately, this area, like so many areas of America, is dealing with a cost-benefit consideration. How much improvement for how many dollars, and where those dollars could otherwise be spent, whether remaining in the pockets of the ratepayers, or in fact providing as much as $100 million for other clean air and clean water projects in the region. Under the Clean Water Act and the National Pollutant Discharge Elimination System, permits for pollutants ultimately have to be granted. This gives the EPA a considerable amount of authority. Early in my career, and even a few years beforehand, the federal government provided substantial dollars for non-source pollution. Those dollars have not just evaporated, but ultimately the demands are virtually everywhere in America. What you see in the Great Bay communities, ultimately we see in California, we see in Ohio, we see throughout America. This form of pollution, primarily driven from runoff and other waste considerations, non-industrial, is in fact an area of pollution once not measured. Today, it in fact is not only measured, but household pollutants are in fact the largest single source of water concerns in America. Whether it's on the Chesapeake or here in New Hampshire, we have a problem. In your case, the need to reduce nitrogen levels by at least 73% back to 1980 levels are a clear goal. The question is not, do you go back to that level? The question is, do you go beyond it? How much can the ratepayer pay? And are those dollars better used elsewhere? The EPA has a mission. That mission is clearly defined. But the levels that EPA seeks is in fact within a judgment decision. It's one of the reasons that federal regulators, and particularly your congressman, asked us to come here and hear from local authorities of whether in fact this balance, this cost benefit, is in fact being properly measured. More importantly, has the EPA bypassed or circumvented the state legislature and imposed its own requirement? As I prepared for this hearing, I found a mixed result. I have to side with the EPA in one sense. There was, in fact, no clear vote of the legislature. And at some point, there is a responsibility for the EPA to act. Do I believe, and do our witnesses believe, that they acted appropriately, that they acted properly, or that they should have insisted that the legislature at least codify what some would say is a significantly flawed study? As we listen to our witnesses here today, it is not for us to be the final judges. It's for us to collect a record, make it available to the entire committee, and then urge the EPA, and if appropriate, the state of New Hampshire, to act in a way that is in the best interest of this community, and more importantly, to set a standard for other projects around the country. As Congressman Gunta and myself recognize, our committee, no matter how many hearings we have, no matter how many investigators do work like this, we in fact are not doing work for one community. This community today is a community that we hope will set the stage for better decisions by the EPA and other agencies around the country. Ultimately, Congressman Gunta's leadership on this has been appreciated because, in fact, as a former mayor, he brought to the Congress an understanding of many of these issues and has been a leader in helping us understand some of the unique challenges faced in New England. And with that, I would recognize my colleague for his opening statement.
Thank you very much, Mr. Chairman, for holding this hearing here in New Hampshire today. This is the first field hearing that I have had here in New Hampshire, and very much appreciate this issue being a central issue to the committee and to you and to our staff. Also want to thank the distinguished witnesses for being here today, as well as the concerned Granite Staters who have great interest in the Great Bay issue. Personally, I want to first mention this is an incredibly important issue to me. This is the first piece of legislation that I ended up introducing in the House called the Great Bay Community Protection Act. The reason that I proposed this legislation as the first piece of legislation is that I was contacted by several of the contiguous communities in this region who expressed some concern about this issue. I think there is one common goal that we all share, in that we want to ensure that the estuary remains a wonderful asset to this region and to our state. There are, however, as the chairman pointed out, some differences of opinion as to how to meet the goal and objective of reducing nitrogen levels. And while I share the goal of reducing nitrogen levels in Great Bay, I think there are various ways that we can address and achieve that objective. So I think that there is a lot of common support. I think there are also different perspectives and different unique approaches into how to meet that objective. But what is the best way to achieve that objective? And that is why we are here to hear different opinions and different viewpoints today. Some of the proposed solutions would carry very steep price tags for local municipalities, small businesses and families, particularly here in Exeter, as well as the communities of Dover, Newmarket, Rochester, and Portsmouth. And I have heard from those communities over the course of the last year about that legitimate concern. So today I am here to listen to these communities and their representatives. I want to hear more about the individual plans that will be presented, and I would like to hear more about how residents will shoulder the financial impact of the decisions being made in their name. It is my hope that when this field hearing is concluded, we will have and leave with a deeper, more complete understanding of exactly what is at stake for the Great Bay estuary and how it impacts everyone. In addition, I feel that we also have a responsibility as American citizens to make sure that the federal government operates within its proper boundaries. Our government was specifically created to serve we the people. It exists to meet our needs, not to needlessly intrude into our lives. For as we are reminded in the Declaration of Independence, that government derives its powers from the consent of the governed. That is why this hearing, I think, is so important. Today, Granite Staters will make their voices heard on the permitting process. I am proud to say to the chairman and to the group here that this is not a partisan issue. Democrats, Republicans, and independents alike agree that EPA needs to take into consideration the views of the many people who live in the Great Bay estuary and who would be directly impacted by the agency's regulatory actions. Governor Lynch, Senator Shaheen, and Senator Ayotte have all raised the similar and same concerns and have shown their willingness and support to work collectively to try to address this issue. And I want to particularly commend Senator Shaheen, Senator Ayotte, and Governor Lynch for supporting a reasonable long-term approach and compromise on how to best ensure that this estuary reduces nitrogen, but also does it in a meaningful way and in a way that does not significantly and financially place an undue burden on the communities that are here today. I also specifically want to commend EPA Region 1 Director Kurt Spalding, who is here and will testify in the second panel, for his personal involvement in this issue. He's met with me personally and my staff to discuss options and alternatives for moving forward to a reasonable resolution. And I commend him and the EPA for trying to find a way to meet the concerns of the communities. Finally, I want to say my thanks to all of you for attending this hearing. New Hampshire is a place where we are very civically engaged and take great interest in our environment. I'm eager to listen to the witnesses and who have agreed to testify today, and I look forward to the question and answer period as well, and I yield back the balance of my time.
I thank the gentleman. I'd now like to ask unanimous consent that 3 letters presented to us be placed in the record. One from the Lamprey Rivers Advisory Committee, one from the Lamprey River Watershed Association, and the last, a letter from Phil Ginsberg, who is a member of the New Hampshire House. Without objection, so ordered. Thank you. Frank, would you like to introduce our witnesses?
Yeah, thank you.
They're your community leaders.
Thank you very much, Mr. Chairman. We have in the first panel 4 distinguished individuals. First, the Honorable T.J. Jean, who is the mayor of the city of Rochester, New Hampshire, as well as a lifelong resident of Rochester, testifying on behalf of the Great Bay Municipal Coalition. Second, we have Mr. Dean Paschal of Paschal Consulting, who has extensive experience in environmental project management and is testifying on behalf of Dover, New Hampshire, and the Great Bay Municipal Coalition. Third, we have Mr. Hall of Hall and Associates, who is one of the nation's leading environmental attorneys and is testifying on behalf of the Great Bay Municipal Coalition. And finally, to conclude the first panel, we have Mr. Peter Rice, who is a water and sewer engineer for the City of Portsmouth, New Hampshire, and is testifying on behalf of the City of Portsmouth.
Thank you. Pursuant to the committee rules, would you all rise to take the oath? Raise your right hand. Do you solemnly swear or affirm that the testimony you are about to give will be the truth, the whole truth, and nothing but the truth? Amen. Let the record reflect that all witnesses answered in the affirmative. Please take seats. In Washington, we have the same red, yellow, and green lights. My predecessor on the committee, Chairman Towns, was always quick to remind people that this is not a new phenomenon, that green means go, yellow means prepare to stop, and red means stop. So I would ask you to try to time your opening statements to be as close to that 5 minutes as possible. I might remind you that your entire opening statement is in the record, and since none of you are presidential administration witnesses, you undoubtedly have a little ability to summarize if necessary. And with that, Mayor, you're recognized.
Good morning. My name is T.J. Jean, and I am the mayor of the city of Rochester. On behalf of the city, I want to extend our sincere thanks for your willingness to hold this oversight hearing, which is addressing issues of critical importance to the city of Rochester and its citizens. The purpose of my testimony today is to discuss with you the severe financial impacts which the regulatory actions proposed by the United States Environmental Protection Agency will have on our city and its citizens. Rochester is committed to protecting the natural environment for the benefit of its citizens and all citizens of our state. However, Rochester and other major cities in the Great Bay Area are concerned that the proposed regulatory actions designed to protect the Great Bay are not based upon sound science and, if implemented, would do more than constitute a waste of scarce local resources. It would financially cripple our city, prevent us from attracting and maintaining our business base, and impose an unreasonable financial burden on our citizens and ratepayers. We are disappointed that the EPA would gamble away our future based on little more than guesswork. This committee needs to stop the EPA now and insist on an independent review of their actions. Like other New Hampshire municipalities, Rochester has been adversely impacted by the recent national economic downturn. However, those impacts have been felt even more significantly in our city. By way of brief background, the poverty rate in Rochester is at 13.1%, the highest of any city in the Stratford County region. The Rochester School District has 32.6% of its student population eligible for free or reduced lunch. Rochester accounted for 31.6% of foreclosures in the Stratford County region, with 118 foreclosures in 2011 alone. The city's tax base, or net assessed value, has decreased each of the last 3 years from approximately $2.36 billion in 2009 to approximately $2 billion in 2011. It is no surprise that this recent economic downturn has resulted in significant job losses in our city. In the last 3 years, Rochester has experienced 504 lost jobs, or 58% of the regional employment loss. The largest of those jobs involved 374 jobs lost at Thompson Center Arms, formerly the city's largest employer. With respect to the employers which remain in the city, shifting and unstable international economics have put additional pressure on manufacturers with global products, such as medical devices, composite materials, machine parts, and aerospace components, all major employment sectors in Rochester. The result of the foregoing is a ripple effect throughout our local economy, in that consumer spending has dropped significantly, having major impacts on the downtown business district and the retail and hospitality sectors in our city. While the financial resources of the city and its citizens have plummeted, the financial obligation imposed upon and accepted by the city to meet the basic needs of its residents have increased. The city continues to finance a number of important major capital expenditure projects to meet the needs of our citizens. These include major bridge and road rehabilitation and reconstruction projects to better serve our community. As a result, wholly apart from those projects which the regulations which are subject of this hearing could impose on the city's annual debt expense is projected to increase from approximately $4 million per year to approximately $6.3 million per year over the next 5 years. This brings me to the financial impacts proposed by the EPA mandates. Rochester has been informed that EPA intends to issue a new permit requirement for both total nitrogen and phosphorus, which would require the city to construct an additional wastewater treatment facility. The city is still retiring a $20 million debt-related bond relative to our wastewater treatment plan improved in 1997. The city recognized at the time that the construction of these upgraded facilities was appropriate to protect the health of the Cocheco River, its aquatic environment, and its users. The EPA's latest mandate will likely require that facility, with outstanding bonds, to be abandoned as EPA has now changed its regulatory focus to total nitrogen. However, the city has been informed by its consultants that EPA's new proposed nitrogen and phosphorus limitations are not based on sound science and will not result in demonstrable benefits to the aquatic environment of the Cocheco River or Great Bay. While I am not qualified to discuss that science, I am certainly able to discuss the financial impact which implementation of those requirements would have on the city. EPA's indifference to mandating major local expenditures every time a new permit is issued based on the flimsiest of information simply must cease. We cannot afford such multi-million-dollar guesswork. Our consultants have advised us that the capital costs related to the upgrade to the city's wastewater treatment facility necessary to comply with the proposed nitrogen and phosphorus limits would be approximately $20.5 million. Assuming a 20-year amortization period at 5.5% interest, this would result in additional debt service costs of approximately $2 million per year beyond those I previously mentioned. After capital construction is complete, additional operating costs required to meet these permit limits would be approximately $2 million per year, beginning in fiscal year 2016. The impact of these costs on our sewer rates is staggering. The city's current sewer rate is $6.11 per 100 cubic feet, already among the highest in the region. Compliance with the latest EPA mandates would immediately result in a 23% increase in rates. By fiscal year 2016, the projected sewer rate would more than double to $12.50 per 100 cubic feet, which would in turn mean an estimated yearly user bill of $1,200 per year in fiscal year 2016. I see my time has elapsed. I just would like to conclude by saying and reaffirming that the city is committed to take whatever steps are necessary to protect the health of its citizens and the natural environment of Rochester and its surroundings. However, the city should not be forced into the kind of economic crisis outlined above for little or no demonstrable environmental benefit. I appreciate your attention to my remarks and hope you will give them due consideration in your role of overseeing these proposed regulatory actions. Thank you.
Thank you. Mr. Pascal.
My name is Dean Pichelle of Professional Consulting, and I'm speaking on behalf of the City of Dover and the Great Bay Municipal Coalition. Congressman Issa, Congressman Ginta, thank you for convening this hearing of the Oversight and Government Reform Committee here in Exeter. The U.S. EPA has proposed limit of technology nitrogen permit limits of 3 milligrams per liter for the Coalition Communities wastewater treatment facilities. Nitrogen removal will require all wastewater treatment plants to either modify their existing facility or completely build new facilities. New Hampshire DES Environmental Services issued a draft nutrient criteria in 2008, which establishes a very low water quality standard. EPA relies heavily on this analysis in justifying strict nitrogen limits in the draft permits. The coalition communities reviewed the nutrient criteria and questioned the underlying assumptions and analysis used. Expert consultants were engaged by the coalition to review both the science and to analyze the potential economic impacts to meet the likely permit limits. Holland Associates of Washington, D.C. and Hydroqual of Mahwah, New Jersey were the nationally recognized technical experts selected. Applied Economic Research of Laconia, New Hampshire was the firm chosen to assess the economic impacts associated with these upgrades. Our technical experts reviewed the nutrient criteria and told us the document has fatal flaws in the methodology and incorrectly concludes that nitrogen is causing excessive algae growth, which reducing water clarity
Mr.
in the
Pichel,
estuary.
could you speak just a little louder? I apologize, but
Sure.
which mic is actually controlling that one?
I don't know if you're
Can-
plugged in, but she's just picking up the sound, so I just want to make sure she's on recording,
Yeah.
that she picks up
Sure.
every word
Yeah.
you say.
Right, and that
Thank you.
mic, the one that you now have closer, that's the one that counts the most from the standpoint of the record.
Okay,
Thank you.
thank you. The consultants further informed us that nitrogen water quality standard established by DES is unattainable and will likely require communities to expend even more resources on stormwater reductions indefinitely into the future at a cost of 2 to 5 times more than that of the wastewater treatment upgrades. Based on stormwater costs incurred in other states, the basin-wide cost to meet EPA's mandates could easily exceed $1 billion. That's a staggering number. EPA has issued 3 draft permits which use the draft criteria as justification for imposing limit of technology nitrogen limits. John Hall will address how this action violated clean water requirements in more detail with you. Our economist Russ Tebow, principal of economic research, is a well-respected national expert. AER was provided the capital costs, operation and maintenance costs expected, and over a range of nitrogen removals. The cost for the 5 communities to meet a 3 milligram per liter limit is $588 million. This represents a huge environmental cost. The costs represent capital costs to build the improvements, O&M, and the cost to finance it over a 20-year period. If we look closer at the economic impacts for the city of Dover, we see that the cost to meet an 8 milligram per liter limit is $36.4 million, and a 3 milligram per liter, $94 million. That's a difference of $58.5 million. The city of Dover and other coalition communities do not want Great Bay to continue to degrade. The communities also want to ensure that the investments to improve the conditions in the estuary are effective and achieve the intended results. It is clear to us that requiring the communities to upgrade wastewater plants to limited technology is unwarranted and will not achieve the desired results at an extraordinary cost to the ratepayers. Times have changed dramatically with respect to funding wastewater. 20 years ago, when the Dover treatment plant was constructed, federal grants paid for 95% of those capital costs. Today, the local ratepayer will be paying 100% of all the costs. In order to move the process forward, the coalition developed an alternative approach to the 3 milligram per liter permit. Nitrogen levels have increased. We do not want them to continue to increase unabated. Nitrogen sources in the watershed are estimated to be 25% to 30% from point sources and 65 to 75% from non-point sources.
If you could wrap up.
Yes. The coalition has proposed an adaptive management plan. It will provide significant nitrogen reduction quickly addresses both point and non-point sources, funds needed for monitoring and restoration, and avoids legal appeals and the waste of financial resources and delays of implementing nitrogen reduction. A copy of that plan is attached to this written testimony. And
Without objection, it'll be placed in the record in its entirety.
Thank you. Coalition believes that the Adaptive Management Plan is an effective and rational approach that will engage the entire watershed community, not just the sewer ratepayers. It will build upon success that will lead to future success and garner the public support needed to fund future improvements over the long term. It will provide significant nitrogen reduction at an affordable cost, and most importantly, provide a process to determine if additional reduction is needed. It will also save over $200 million in expenditures that have no proven need or benefit. With that, I will conclude, and thank you very much.
Thank you. Mr. Hall. We'll take a moment for the mics to catch up.
To rearrange. Thank you. Good morning, Mr. Chairman Issa, Congressman Ginter, and members of the committee. My name is John Hall. I'm a principal of Hall & Associates, an environmental firm that represents the Great Bay Municipal Coalition. As mentioned in earlier testimony, the region's actions will needlessly impose restrictive nutrient reduction requirements that will adversely impact these local economies for decades to come, and unfortunately not produce the intended environmental improvements. In seeking to impose some of the most stringent nutrient limits in the nation, the region has also violated several mandatory duties under the Clean Water Act, as well as several other EPA rules and policies that are designed to protect due process rights and ensure that only reliable scientific methods are employed in regulatory decision-making. As noted earlier, the region has issued 3 draft NPDES permits that impose very stringent total nitrogen requirements. These nitrogen limits are based on draft water quality criteria that have never been formally adopted by the state or formally approved by EPA, a practice that is strictly prohibited by the Clean Water Act and EPA's regulation known as the Alaska Rule. To quote EPA in its questions and answers on the Alaska Rule, I quote, "The CWA Section 303C3 is explicit that all standards must be submitted to EPA for review and must be approved by EPA in order to be the applicable standard. Under actions under Section 303D, the state must base listings on the applicable water quality standard. The state cannot use a new standard for CWA purposes, e.g. in a final permit, until EPA has approved that standard." End quote. However, the region simply ignored these requirements. It knew it had these mandatory duties and early on recommended that the state quickly move to adopt the criteria into its standards, which would have then given the public an opportunity for active input. When the state failed to do so, the region came up with the idea to call the draft numeric criteria something else, a narrative criteria interpretation, as if that changed any procedural requirements or the mandatory duties under the Clean Water Act. In addition, if not more importantly, the region knew that there was no cause and effect relationship between total nitrogen and eelgrass loss for the estuary, and this was based on prior federally funded research specifically directed at this issue. Nonetheless, the region adopted the position that stringent nitrogen limits were essential to restore eelgrass populations, and limits of technology were mandated, which would then also trigger very stringent land use controls in the same areas. The region's insistence on using unadopted numeric criteria in permits and in permit listings plainly violates the public notice and comment requirements included in the Act in Part 131. After circumventing the required approval process in March 2011, the region then undertook additional efforts to exclude the public from a peer review process that was intended to bless the criteria. When the coalition found out about the impending peer review, they specifically requested an opportunity to participate in that action. The coalition submitted comments to the state and region based on major technical deficiencies in the draft criteria. However, the region refused to allow the peer reviewers to address any of these points and concerns. This is directly at odds with Section 101E of the Clean Water Act, which mandates that the agency must promote public participation in any review and modification of standard, not prevent it. Since the peer review, the affected communities have repeatedly submitted detailed site-specific information, clearly showing the proposed permit requirements are fundamentally flawed. To date, all of those submissions have been ignored without comment. It is now apparent that serious regulatory violations, bias, and, in fact, scientific misconduct underlie the region's actions. The communities believe that the record is clear that the region was determined to implement a predefined regulatory agenda of stringent nitrogen limits, one, even after a federally funded technical advisory committee for the Great Bay confirmed there was no cause and effect relationship between nitrogen, transparency, and eelgrass loss. Two, even after EPA's own Science Advisory Board stated that the type of simplified analysis the region now wanted to use to support a more restrictive approach was not scientifically defensible. Three, even after the region itself internally identified major scientific deficiencies and significant conflicts with the Science Advisory Board recommendations. These are serious issues. What is the point of having a local or federal Science Advisory Board if the agency is simply going to ignore the findings and then continue to employ methods that are criticized as fundamentally flawed, and for that reason will likely misdirect resources? In closing, it's apparent to the coalition communities that the region appears to have no intention of conducting a comprehensive, impartial scientific review. For that reason, the coalition submitted a letter to EPA headquarters on May 4th documenting science misconduct and requesting that the matter be withdrawn from the region and transferred to an independent panel of scientific experts. The coalition continues to support this request as the only viable means for an objective review that will help ensure the local resources are not squandered on misdirected policy mandates. We appreciate the committee's investigation into this matter and hope that this can be resolved in the near future. The details supporting this testimony, including the misconduct letter and with numerous attachments, are included in the record. Mr. Chairman, I request that they be included.
Without objection, they'll all be included in the record. Mr. Rice.
Thank you.
Thank you, Mr. Chairman, Congressman Ginta. On behalf of the City of Portsmouth and the Great Bay Municipal Coalition Communities, I'd like to thank you for this opportunity to testify today. My name is Peter Rice. I'm the City Engineer for the City of Portsmouth, and I've worked in this position for the last 10 years. Prior to working for the city, I worked as a consulting engineer. I'm a registered professional engineer, and I've served on a variety of state water, wastewater commissions and organizations, and have been involved in the Great Bay nutrient issues since 2002. A copy of my resume has been included in my testimony. The City of Portsmouth is a small city, about 21,000 people, but despite our small size, we have big city infrastructure problems. The city owns and operates 2 wastewater treatment facilities, has over 120 miles of sewer pipe, and manages 20 pumping stations. Communities such as Portsmouth want predictable, scientifically supported environmental regulations that deliver demonstrable environmental benefits. Within such a regulatory framework, limited municipal resources can be secured, budgeted, and invested wisely to deliver necessary services with a maximum environmental benefit. In 2002, I assumed my predecessor's position on the State Water Quality Standards Advisory Committee. On this committee, I became involved with the Nutrient Technical Advisory Committee for the New Hampshire Estuarine Project, which is currently known as Piscataqua Regional Estuarine Partnership, or PREP. The purpose of this Technical Advisory Committee was to provide technical peer review on the science used to develop water quality standards for the estuaries of New Hampshire. A specific focus of this committee was whether and how nitrogen could be affecting the bay ecology, in particular eelgrass populations. In 2005, EPA directed the state to develop nutrient standards for the estuary. This was part of a national effort on EPA's part. Up until late 2008, nitrogen, although a concern, was not identified as a source of impacts on the bay. In particular, it was concluded, based on federally funded studies, that increased nitrogen levels had not caused increased algae growth and had not adversely impacted water transparency in the bay. I've attached with my comments presentations given by the New Hampshire Department of Environmental Services staff relative to these conclusions. In 2008, there was an abrupt turnaround. At a State Water Quality Standards Advisory Committee meeting, a simplified data analysis was presented, which ignored previous detailed studies and reached an opposite conclusion. This incorrect analysis was supported by EPA and subsequently became the basis for setting standards and declaring virtually all waters in the estuary nutrient impaired. All of this occurred without any formal adoption in accordance with the law or formal approval by the criteria by EPA as a new water quality standard. Thus, the impacted communities had no opportunity to challenge these changes. As a result of this about-face, Portsmouth reached out to other communities with wastewater treatment facilities to discuss the state's water quality criteria. The change in the state's conclusions with regard to the role in nutrients spell trouble for the municipalities discharging into the Great Bay estuary. The proposed criteria for nitrogen is not achievable and has been used by EPA to claim that nitrogen must be treated to limit of technology at wastewater treatment facilities and that stringent stormwater treatment must also be implemented to improve water transparency. On March 15, 2010, I attended a Water Environment Federation EPA briefing in Washington, D.C. Mike Hanlon, the EPA Director of Wastewater Management, advised attendees that the EPA didn't have the time or money to do the science, and that the EPA was going to apply the Chesapeake Nutrient Criteria program nationally. The following day, at a congressional briefing breakfast, I was told by the Regional Administrator Spalding that until Portsmouth and other communities develop their own science, EPA would not consider our community's concerns. Complicating EPA's apparent limited time and money were the interests of non-governmental organizations which appear to be having a disproportionate impact on the water quality process and setting of permit limits. I was told that the regulators were more worried about possible lawsuits by NGOs than they were afraid of municipalities. This deference to the NGOs is an indication that EPA is more concerned about policy issues than getting science right and implementing cost-effective solutions to protect and improve the environment. This involvement by NGOs may explain why our repeated requests for involvement of our technical experts were either rejected or trivialized. For example, Portsmouth was given assurances by representatives of the New Hampshire Department of Environmental Services that we could participate in a formal EPA peer review of the draft nutrient criteria. Instead, Portsmouth and other communities were excluded from the peer review process at an EPA level. This EPA peer review was a carefully orchestrated exercise designed to provide an appearance of scientific credibility to a fundamentally flawed nutrient criteria that met EPA's policy objectives. I have attached the correspondence relative to that process in my statement. Rejecting the public's...
Without objection, that'll be placed in the record.
Thank you. Rejecting the public's request for an inclusive, objective, and open process, the regulators have delayed action which would have yielded environmental benefits in the near term. By ignoring good science, the EPA's regulatory process has set up unachievable goals which will misapply scarce public funds while not achieving the intended goals, and force communities to spend their money on lawyers instead of science and solutions. In summary, the Great Bay Municipal Coalition is committed to protecting and restoring the Great Bay, but we believe the existing science does not support the regulatory decisions being made and should not be the basis for NIPT's permits. I'd like to thank you for this opportunity to speak today.
Thank you. And I'll recognize myself for a first round of questions. As you may have seen on C-SPAN from time to time, our questions are not designed to be softballs, and they won't be here today. Mayor, you spent a lot of time telling us about the money cost and the problems in the community, the unemployment and the like. Do any of those provide any legitimate reason to not go forward with whatever is the requirement under the Clean Water Act and whatever would provide a return of health to the estuary?
Well, I can only speak to the point that right now, if we were to encumber that amount of debt service to meet the nutrient limits, the ratepayers of Rochester would have their sewer bills double, and that would remove basically all disposable income that they might have to help in the business sector.
No, I appreciate that. The question was one that I think in Washington we have to be sensitive to, but hopefully here in New Hampshire you're sensitive to it too. Ultimately, if it is necessary to double the rates in order to clean up the estuary to an acceptable level, in other words, to mitigate the damage being done by human activity, isn't the requirement absolute if it's necessary?
If it's necessary, absolutely, yes.
And I just want to make that clear because often we sort of talk about what we can't afford, and in this case, we are the polluters. Every home, every runoff in stormwater and so on. So, I didn't think you were saying that one offset the other than we need to be very careful to make sure that in fact it is necessary. Mr. Peschel, you went a lot into procedure, as did Mr. Hall, but particularly you mentioned the state. Well, I'm sorry, Mr. Hall mentioned that. Let me ask you a question. You feel that the science of essentially half as expensive a solution is the appropriate science, don't you?
I do, and I think, you know, based on the information that our consultants, the technical consultants have provided, there is great doubt that what is being proposed by the EPA is necessary.
Well, now, I'm a businessman, and for the 20-plus years I was in business, I know that you generally get from your consultants what you seek to get. In other words, they work hard to reach a goal that you ask them to get. I'm presuming that you asked them to get the least expensive way to reach a goal that you thought was reasonable. Is that correct?
No.
You just gave them a blank slate of what would it take?
What we told them when we hired our consultants was that we wanted an honest review of the information that was being presented as being justified by the state.
What if they're wrong? What if they're wrong? What if the EPA allows you to go forward with your level, the 8 milligrams rather than the 3? What if, in fact, 3 years, 4 years, 5 years, roughly 2020, you'd be at that point, you see that it's not working?
Then we would have the information that we need to make the additional improvements. That has always been our understanding and our plan.
So
what we don't want to do is spend money that is not necessary.
Is that true? I mean, each of you represents, I guess, 4 of the 5 cities involved. If, or at least is affiliated, if in fact your plan were to be adopted with a measure and renewal period, is it your understanding that you don't get to do this for 20 years for the life of those bonds, that you might in fact, by choosing a less expensive solution, if you don't achieve the goals that in fact, in other words, the return of health of the estuary, that in fact you could find yourself back again with a new financial impact? Is that an understanding that you have here today?
Absolutely, and any design that we would undertake to meet, say the 8 milligrams per liter, if we were to be found that it's not sufficient, we haven't lost anything. The actions are supplemental. We would just add on to what we've already done.
Sort of when you cut curtains, you want to make sure you cut them, but not too short, because you can take more away. You can't add on.
Right. That's not the case in this particular situation. We can add on, and it won't have been money lost on the initial.
Mr. Hall, you went into great detail on the violations of procedure. Ultimately, you also, I gather, believe that they reached the wrong conclusion. But even if they reached the right conclusion, do you feel that in fact the lack of due process on both sides is part of the fatal flaw of EPA reaching this conclusion?
Well, there is a serious error and lack of due process in the manner in which the procedure went forward, and that does need to be corrected. Quite frankly, we wouldn't be sitting here raising just a due process issue.
Well, but I'm asking for a reason. We have before us a document that indicates EPA is scared stiff of the sue and settle crowd, the NGOs that will sue if they fail to abide by every nuance of the rule. Ultimately, if they had erred on the side of you with this same, in other words, if they'd picked you arbitrarily and quickly, wouldn't they have been in the same boat, except in this case it would have been NGOs suing them?
Well, actually, it was the NGOs that originally sued EPA to establish the Alaska rule. They said, you are changing water quality criteria without going through the process. You're cutting off our ability to provide the science, the input, the process. You're cutting off our ability. So they're the ones that originally sued to make this.
So all you're really asking for is what the environmentalists demand and have sued to get, an open and fair process with certain comment requirements that you've been denied.
That would be a very fair way of stating the position.
Let me just ask, and if I could ask a couple more minutes, I said this in my opening statement, isn't the EPA also in a box because of inaction by the state legislature? In other words, at some point, we in Washington, if a state simply chose not to act, and so far the state legislature has not acted, isn't there a time limit at which, at some point, we have to allow the EPA to take some action, regardless of their violating procedure? Ultimately, they did have a need to act if, in fact, a state legislature never acted.
Oh, most certainly. There's a provision under the procedures of 303C3. if a state refuses to take action or delays in taking action on updating your water quality criteria, the EPA sends them, it's basically a 60-day notice letter.
Has the EPA sent that?
No, that letter was not gone out. That was the letter that they sent to the state of Florida that triggered the Florida water quality standards adoption.
So essentially, they haven't given the state legislature notice to sort of pay rent or quit, to in fact do its job or be bypassed.
Correct. That has not happened.
Lastly, Mr. Rice, and I'll be brief, but it sounds like you're describing in this process, from the conference you attended, a ready, shoot, aim procedure going on by EPA. They tell you they have no time, they tell you have no money, but they're saying do it anyway. Is that pretty fair?
That is pretty accurate approach or statement, yes.
And where is, in any of your understanding, where is in fact the assumption that the science has to be established as disproving from the EPA rather than EPA coming down with science that supports their assertions on water or air? Because it sounds like they're asking you to prove by your science what you want to do. Well, in fact, they say there's no time and no money for them to establish scientific standards in this case.
We asked to participate in the scientific process 4 or 5 years ago. We said that we would participate financially, contributing to the sampling process as well as with our technical experts. We were told at that time that they had their science and you don't need to participate. We felt that our participation would have benefited the process and would have gotten us farther along. In order to know if a solution works, you need to have a foundation that's solid so that a financial decision is made. You can build and measure if that decision was good. If you don't have an ability to measure if something is good or not, that does what you think it's going to do, you'll continue to spend money on a solution that may not be a solution. So what we argued was that we needed to be able to really build and measure, and that's part of this adaptive management approach, was that we would be able to say we're not going to preclude better decisions in the future by jumping all the way to some foregone conclusion. We would be able to build, see the improvements. If their science is correct, we should see a 40% reduction on our incremental step in terms of the nutrients going into the bay. That change should have a marked improvement if their theories are correct. We do not believe they're correct. We do not believe the science supports the conclusions that they made.
Let me just close with, in all of your statements, you talked in terms of eelgrass not being affected by this. So your theory is you will do the reduction for other reasons, and that ultimately the grass will continue to have a problem that you don't know the source of. Is that roughly correct?
Mr.
Yes,
Mr. Chairman,
because it was water clarity you
more,
mentioned.
More importantly, they actually do know the source of the problem. The research was completed. It concluded, which was kind of obvious when you looked at the data, that nitrogen had not caused the effect that they thought it did. There's an interesting thing that happens in the watersheds in this area. There's a lot of swamps. When it rains a lot, colored water comes out of the swamps. When colored water comes out of the swamps, it goes into all the tributaries and turns them dim. The light can't penetrate. The federal studies found, yes, in fact, that's the primary cause with why there's poor transparency in various areas. Having found that conclusion, it was then tossed out because there was this drive for nutrient criteria. I mean, it was as if it was a solution in search of a problem. So that's the unfortunate part, and that's what Mr. Rice is talking about having a...
That you'll reduce the nutrient and water clarity will not change, therefore...
It doesn't change it. Yeah, it has no effect on it.
I've exceeded my time. Mr. Gunter.
Thank you very much, Mr. Chairman. I want to start with Mayor Jean. First, I just want to ask you a simple question. Do you support ensuring that the Great Bay remains clean? Absolutely. Okay. During the course of your testimony, you commented that protecting the natural environment for the benefit of its citizens and all the citizens of New Hampshire is important, but that you were also concerned that the nitrogen and phosphorus discharge limits proposed by the EPA were unnecessarily strict. As an alternative, another testimony, the AMP, or the Adaptive Management Plan, has been proposed. Rochester has joined in supporting the adaptive management plan. Can you talk to me a little bit about why that adaptive management plan is more reasonable from a financial perspective for the city of Rochester?
Certainly. Right now, the city of Rochester is at approximately 30 milligrams per liter nitrogen. The adaptive management plan brings us closer to 80. The most important part of the plan is it will give us some time to collect some hard data that would show whether or not what we're doing for total nitrogen will actually improve the status of Great Bay or not. And we felt that that was probably the most cost-effective and reasonable number to achieve, and that's why the city supports that from a financial standpoint.
Now, you talked a lot about the potential cost to taxpayers. Taxpayers in the city of Rochester have a tax bill, but they also have a sewer bill. You mentioned a $2 million annual increase in the bond for, I would assume, the wastewater treatment.
Correct.
You said that would double the rate, and you testified the rates. Can you give me an idea what the average amount that a family or a household is paying currently for?
Sure.
And is it billed quarterly?
It's billed quarterly, and right now, at the current rates, you're looking at a sewer bill that's probably about, I'd say, close to $600 annually. So if you were to impose the debt service that a wastewater treatment plant upgrade would entail, you're looking at about $1,200, and that's just the sewer side. That doesn't count water. Of course, there's both sides to the water
Right.
and sewer bill.
So that would be just if this mandate
Correct.
was implemented.
That's correct. And what's important to note is, of course, if this were an upgrade that would be spread between the entire commercial and residential tax base, that would be one thing. But this is focused directly to the ratepayers who subscribe to the wastewater treatment service that we provide. So it's a smaller number as opposed to the broad width of residential.
And you mentioned that the valuation of the city, since I think you said 2009, has been declining,
Has diminished from $2.6 billion to approximately $2 billion.
which is not uncommon for economic conditions that the entire country's in. There are many other communities that are also, their value is declining,
That's correct.
which means that either, just from a mathematical perspective, either, I mean, so you have less tax base to tax. So if you're going to have the same amount of money, the same amount of services, you've got to increase taxes, or you've got to somehow cut back on the expenses of the city to equalize that reduction in value.
That's correct. There is a reduction in that.
Now, has the tax rate increased over the last several years in the city of Rochester?
It has.
What's the rough average increase?
You're looking at approximately 3%, 2.5% to 3%.
Okay, so this
over
would,
the last 3 years.
and this would be in addition. So this issue, this mandate, would be in addition to a 2.5% to 3% annual increase.
That is correct.
The second point I wanted to make with the mayor is that the Great Bay Municipal Coalition, which includes Rochester, has initiated litigation against the state and state DES, alleging that it violated the state rulemaking process by neglecting to conduct a formal rulemaking process. I don't know if I should ask you this or maybe Mr. Hall and Mr. Rice. My particular question is, if the state of New Hampshire or if EPA were to follow the procedures that the EPA put in place and ensured that the state legislature had a proper review, that obviously would take some time. It would happen over either one cycle or maybe 2 bienniums. That would provide at least some additional time to create different or better science, or maybe more agreed upon science. But secondly, it would put you in a position as a city, one of the contiguous communities, to try to identify a means in which you could pay for this long term. Is that a fair statement?
That would be fair, and I could defer to Mr. Hall if there's anything that he'd like to add about the DES process, but I think that's an accurate assessment.
Well, I'll in the next round of questioning, maybe I'll get into the specifics on procedure, because I think that is extremely important.
The only point being, the chairman raised whether EPA had taken the step of sending the letter to the state saying, why have you not adopted the standard? because the regulatory agencies did not do what they were supposed to do, we're now going to court to make them do precisely that. So, you know, we're the ones that are moving the regulatory process along its proper path. We wished we didn't have to do that, but that's the situation we're stuck in right now.
And the final question I guess I want to ask Mayor Jean, I know that your method of governance is one of inclusion, and I know that one of your focuses has been trying to improve the economic condition of Rochester as an extremely important city to the county and to this region. If you were to have 5 businesses that you were courting and you were to include as a matter of proper disclosure that there's a potential that there would be significant increases on this side of the ledger, how would that affect your ability to attract new smaller businesses, job creators, and how would that put you in a competitive or advantage or disadvantage to other communities?
From an economic development standpoint, the increased rates would certainly put us at a disadvantage, not only to the surrounding communities within Stratford County, but really would put the entire Stratford County at a disadvantage and encourage business to settle maybe in Hillsborough County, Merrimack County, where there are less stringent regulations that would cause wastewater.
Because this is not just affecting Rochester,
No,
it's affecting...
This is a regional impact,
Okay.
and that's why we're here today.
Thank you very much. I yield back the balance.
Thank you. And we'll just do one quick second round because we do have another panel to get to. And I had a couple of questions. Mr. Rice, you testified that, you know, for your first years in 2002, 2008, essentially the State Water Quality Standards Advisory Committee took one approach as to nutrient from a technical advisory standpoint. And then in 2008, there was an abrupt change. Can you account for what caused, if you will, what science supports an abrupt change in how nitrogen is looked at?
I can't justify the abrupt turnaround based
But
on
you saw
science. Based on policy, I was told by DES personnel that they were being directed to come up with a strict nutrient limit and that they had to make the numbers work.
So what you saw was a policy change without science that led to essentially science being found to support a policy decision already made.
Correct.
That's not uncommon. We see that in Washington. I guess, Mr. Hall, that sort of brings us to that question of these procedures that you're alleging, and I think are pretty well documented, these shortcuts are being taken. Aren't they, in fact, the exact fatal flaws that both sides need to guard against? In other words, even though it's a long and laborious process of comment and inclusion, that ultimately that's a requirement, whether it's objections from the left or objections from the right on any particular issue, in order to get to a decision that we all have to live with. If you will, that's the due process guaranteed, even if the outcome is not always what we wanted.
Well, that's certainly correct, Mr. Chairman. I mean, we're not trying to dictate an outcome, but we should have our process, which then allows us to put in the requisite scientific information to show what should or shouldn't be occurring. And that, again, it applies to both sides, so I agree.
And I guess one follow-up question that I'm particularly interested in, isn't it possible that with all the due process, with the legislature acting, with science being re-looked at in an open and transparent way, isn't it possible you'd lose? That in fact we'd end up with less than 8, perhaps as little as 3, that the ultimate standard may not be where your particular experts found it?
Well, I would offer the following observation.
I was hoping for a yes or no.
No, actually the answer is no. The scientific information is so
in other words, you're comfortable with your science, but let me ask it another way. The process would at least create the possibility that people of good faith would look at the science and reach a different decision that might not be exactly the same as yours.
Yes, Mr. Chairman, and in fact, when we asked for the independent peer review, our statement going in, and I mean the coalition statement was, get 3 truly independent experts, and there are top experts in the country that know these issues back and forth. get 3 experts. If they say we're wrong and we need to do it, we will go figure out a way to find the money and get it all done. But if they say it's like they did the last time, it's not correct, we don't expect another policy decision to foist a billion-dollar nutrient reduction program.
Mr. Rice, you seem to
Yeah,
be eager to give an answer.
Well, it's just for perspective.
We do this in Washington. We give answers where there are no questions, but
Well, there's points to be made, right?
yes.
As the city engineer, I'm responsible to look at the data that's available and to make recommendations to the decision makers, our city council, our city manager, based on that information. That information needs to be able to support the decisions and the investments that the city makes. Reviewing this information does not support these significant capital outlays.
And I guess as a city engineer, if you needed to build a 1 mile long road that would accommodate a certain amount of traffic per day, and you calculated 2 lanes, and somebody else said, but I want 4 lanes because it looks prettier, that ultimately you'd be looking at, yes, but why should we pay twice as much for twice as many lanes unless we need them?
Correct.
And so in a sense, this is what this really is, a decision about what it takes in the way of capacity and mitigation in order to achieve a goal that is already specified and agreed to by all of you.
Absolutely.
I know there's 4, I keep saying 4, but I know there's 1 city that we were not able to get a witness on either side available for. Would you all agree here, and particularly Mayor, since you bind the city to a great extent, that if the process is adhered to, that if EPA does what it's supposed to do, if your legislature, if appropriate, does what they're supposed to with the 60-day notice, if that comes through, that ultimately you would recognize and abide by whatever the decision is and whatever the cost is if the due process is properly run through?
That's correct. We'd have no choice.
You'd have no choice, but I guess I'm asking only, for us, we'd all like to have the best outcome. I would like healthcare to cost half as much as it does, because I've got to tell you, the healthcare debate in Washington would be a lot easier if it was half the cost. Ultimately, we wouldn't have a crisis in Medicare. If I can't make it half the cost, I at least have to arrive at the least waste and fraud that I can and then pay the bill. That's sort of the situation you're in, is that you'd like to protect the citizens of your city by getting them the most accurate and least expensive but effective decision with a legitimate due process. Well, that's to a great extent what Congress has an obligation to do with all the federal agencies, and I will tell you that's my goal when I leave here today, is to ensure not that your particular solution win, but that the process be adhered to so that ultimately the best solution at the lowest cost possible be achieved. Thank you. Mr. Ginta.
Thank you, Mr. Chairman. Mr. Rice, you're here on behalf of the City of Portsmouth. Can you tell me what, if any, votes the City of Portsmouth took relative to this particular issue or the adaptive management plan?
I will and I can, but if I misspeak, my
Sure.
Assistant City Attorney's here to let me
set you
know.
straight.
Yeah, to set me
So
straight.
we've got an engineer and an attorney.
Yeah,
What a
it's
combination.
It's a bad combo. It's a bad combo. It's my belief that the City Council did vote for the adaptive management approach, and we did budget monies that were passed to move forward with that approach in this year's budget.
Can you? Sure.
And then the other question you had was for the the other votes that they've been taking. The city's voted and committed to moving forward to build it. We're upgrading a treatment plant to build that treatment plant to 8 milligrams per liter with the ability to treat to 8. So that's another vote that was taken.
So just to sort of put this in perspective, right now we're talking about anywhere of a discharge from 20 to 30 milliliters, correct? I mean, current discharge?
Yeah, right. Currently we're around 20.
And different communities are at different levels, but
Yeah,
it's roughly 20 to 30 based on the communities. So you're at 20, Rochester could go as high as 30 in certain years, but that's where we are today.
Yeah.
EPA requirement is to get to 3, and the coalition communities would like to get, the goal is to get to 8.
Is the first step, correct. And obviously what we would do is we'd build and measure. You know, the idea is, did it have the results you were hoping for? You know, is it the right step, and do we need to do anything beyond that?
So you don't object to having a plan, you don't object to ensuring that Great Bay is clean, you don't object to reducing nitrogen. What you're objecting to is, it sounds like, is the mandate to immediately get to 3.
We don't feel the science supports going to 3.
Okay. And you have offered to the EPA, have you offered to the EPA
Yes.
Your alternative?
Yes.
And what response have you gotten from the EPA?
The request, I think, went through the DES originally in a letter to the EPA, and the EPA responded that it was not adequate, that you had to go to limits of technology.
Okay. Can you talk to me a little bit about what you identified in your testimony in regards to your attendance to a Washington event, a Water Environment Federation EPA staff briefing on March 15th, 2010? You talked about it a little bit. Can you talk a little more in depth about what you were told?
Yeah, I mean, there was a briefing through our New Hampshire Water Pollution Control Association, the New England Water Environment Group. We go down annually to get updates and have a chance to chat with our representation down there, to bring up concerns and get information. At a staff EPA briefing to our organization, they were talking about the Chesapeake Bay, and they talked about other estuaries, and that they were taking this approach and expanding it nationally. And I pointed out that there were site-specific differences with each estuary, and it appears to be a one-size-fits-all. And why would you do that? Our bay's different than elsewhere. And the response was, we don't have the time or money. We're moving forward, and that's just the way it is, and you just have to accept it.
So they don't have the time or money to do proper, but exactly. And Mr. Hall, you did actually mention in some of your comments that there are geographic differences nationally on what would produce the transparency issues or the discoloration of different water bodies.
That's correct. Actually, if Chesapeake Bay had the algal level that you have in Great Bay, they would be doing handstands. It is that low. The
compared to Chesapeake.
Compared to the Chesapeake, and it's
nice to be colder.
Colder, and more importantly, I don't know if you get a chance to go eat some seafood down at Portsmouth Harbor.
My staff has contributed considerably to the economy in the last 2 days.
Ask them to watch the tidal exchange. It is impressive. The amount of water that comes rushing through every day, the detention time, which is a critical controlling factor in any nutrient growth in a bay, is I think about 13 to 18 days in Great Bay. In Chesapeake Bay, it's like 9, 10, 12 months. So the amount of difference that you can have in algal growth is huge in Chesapeake. In Great Bay, you can put nitrogen in and it actually doesn't affect the algal growth, which is exactly what the data showed. What we were astounded with about was after they looked at the data, EPA looked at the data, and they were shown that the nitrogen went up, the algae did not change. They still kept claiming that nitrogen caused more algae and caused worse transparency. The data confirmed it never happened. So yes, there are major differences in this system compared to others. And I might note that your technical advisory committee from 2007 concluded you shouldn't use the data from other estuaries because this one is so different. And I don't know where that recommendation went, but it certainly got ignored in the end process.
Mr. Chairman, may I have one additional minute? Okay, thank you. Mr. Hall, we are going to hear in the second panel from the EPA, specifically Mr. Spaulding, and I suspect what he, to make the points for the EPA, will talk a little bit about PREP, the Piscataqua Region Estuaries Partnership, and that report from 2009 and how it justifies the proposed standards by EPA. Can you talk a little bit about, from your perspective, what PREP what that document states?
Sure.
And maybe if you have any concerns or if there are any also legitimate points you want to make about that document?
I think the simplest analogy would be the following. Suppose you went into a doctor and said, I'm having shortness of breath. And the doctor said, well, this could be anything from indigestion to you may need bypass surgery. You know what we need to do? We need to run some very specific tests to figure out what the right diagnosis should be. The doctor runs those tests, concludes, in fact, it was indigestion. You go back to meet the doctor again, and then the doctor tells you,
Time for a heart transplant.
it's time for a heart transplant because I have an opening on my schedule next week, and I needed to fit somebody in. That is exactly what happened with the 2009 criteria document. They did the specific studies. When it confirmed that the specific results or conclusions where transparency was not affected in the way they thought, they then switched to a simplified diagnosis, plotted data in a way, and by the way, my background is in mathematics. I also have degrees in environmental engineering. If I had handed this assessment in a master's program as a basis for calculating a nutrient limit, I would have gotten an F. The EPA Science Advisory Board specifically said you can't use these kind of simplified methods to predict complex nutrient criteria. Okay, we brought that to EPA's attention, and now that SAB report happened about 6 months after the state finished their report. So we thought, we'll bring this forward. Obviously, they've made a mistake, and they'll just fix it. But no, since that date, the Science Advisory Board position that you can't do these kind of analyses was ignored, as was the specific diagnosis that this wasn't a transparency issue. So, yeah, we've got a few problems with the 2009 documents, and that's why we've been asking for an independent scientific review from day one, because I cannot imagine any credible set of knowledgeable scientists looking at the evaluation and saying anything else other than you need to change that.
Thank you, Mr. Chairman.
Thank you. I'm going to just follow up because there was one thing that I didn't get in the last round. When one of you talked about the 1997 water treatment plant, which gets you only to 30 milligrams per liter, right, currently. So in 1997, in the year of our Lord, 1997, way back then, 30 was good enough. As an engineer, how long has 3 been technically possible? How long has 8 milligrams per liter cost what it costs now in your study? Is this a science where every year, if you know, a little bit like trying to have the greatest computer 25 years ago for millions of dollars, I have in my pocket behind me, it's an iPad, you know, in my briefcase. But a $20 million computer in the 70s was not as powerful as an iPad, nor did it have as much memory. How is the science going relative to being able to make those kinds of removals? If 3 is technically possible but expensive today, 8 is cheaper, and in 1997 you were at 30, has it progressed that quickly?
There have been improvements in the science and the understanding of these systems. The big difference between a computer and a biological system, a wastewater system is a natural biological system. We take what naturally occurs in a river and we condense it down into a treatment plant. So we get more bang for the space available.
Right, but for example, reverse osmosis is in the order of 10 times less costly to do water purification in that system than it was a few decades ago. My reason for asking is, if in fact the EPA were to arrive at a decision that 8 looked good enough today, 10 years from now, 15 years from now, just as 15 years ago, if they come back and there's a reason to go to 4, is it likely to cost less or more because of technology breakthroughs?
It really depends on a number of different things. The operation costs of these technologies are not insignificant. The reverse osmosis is energy intensive. A lot of these low-limit biological systems require additional chemicals, methanol, which is dependent upon energy prices. So
last time I checked, you don't have a lot of natural gas coming into New England yet.
Right, but if you look at it in the capital cost, it may be cheaper in terms of the capital, but the operation and maintenance costs will offset the cost. So, you know, it's crystal ball to a certain extent. Our understanding of the biology and how the bacteria work has significantly improved, and we're doing the best. You know, we're really milking a lot out of what they do naturally. But when you start adding chemicals,
I guess let's leave the dollars out for a moment. Could you have gotten to 3 milligrams per liter, the existing science, in 1997?
Not easily.
Probably not easily. I mean, even
I mean-
today, 3 is a seasonal type thing. During colder temperatures, it's going to be challenging to meet the 3.
So it's
If
a developing standard. It's also developing technology, and finding the right mix today doesn't preclude the fact that you could do potentially better, even for a small difference, and do it a few years from now.
Absolutely, and that's it's really why we say this build and measure approach doesn't preclude doing better things in the future. However, going to 3 today does preclude, because it takes away resources. And you had asked the mayor, what type of impacts this could be having, negative other than just financial. The unintended consequence of raising sewer rates in all the sewered communities will drive development into the non-sewered areas. And as we've seen, non-sewered areas are really the source. The runoff is really the source of the problems. And granted, some of the cities have runoff problems, but you'd be expanding sprawl and moving more runoff issues out of the sewered areas.
Well, and that is one of the interesting challenges, is that when your project's complete at 3 or 8 or whatever level, I'm sure the vast majority of the state will still be and its residents will be at a level higher. Thus, you'll be the good actor, but some of that waste will still be going into the same estuary.
Correct.
Okay. Well, I want to thank Mr. Ginta. I want to thank you all for your multi-panel answers. If you possibly can remain for the next panel, we'd appreciate it. If you have comments or additional items that occur as a result of Mr. Spaulding's testimony, please understand we're going to leave the record open for 5 days for your additional comments, in addition to outside organizations. So thank you, and if we could reset for the
Thank you,
next
Mr.
Thank you
Chairman.
very much.
Thank you. You need a break? Okay. Yeah, you stay live the whole time.
We're currently having a meeting.
So this side is.
Are you getting what you need? Good to have you on the road again. Good to see you again. When are we going to get one of the members up here for one of these things? It's funny is when we do one for Mr. Cummings or Mr. Towns, we tend to get a pretty good turnout on both sides.
What? No, it was not mine. Oops, sorry. Let me into the restaurant. They weren't on, were they? Sound-wise.
Sound-wise, it's terrible.
Yeah, no, it was quiet.
Well, I mean, they're not amplifying, they're just for recording.
Oh, they're just for recording. Oh, they're not good enough for recording.
Well, no, I'm
Oh, well, I'll help you. My voice tends to carry. So. That's true. That's true. Yeah.
If somebody wants to drive it around the block and repark it, I don't care. Hi.
Including several years in Washington. Outstanding.
I will try to run this the right way.
42 communities
On the estuary?
just the whole area, the whole watershed.
Right.
Which this legislature established a couple of years ago. It was its first change in its organization. Familiar with all the issues and the people. It's too bad to see it take a little slightly adversarial twist because it really takes the working together.
Yeah.
Take the resources
I
of the
think, yeah.
agency.
And I think we may get it back on track.
Well, as I said at a congressional breakfast, sitting next to it's well. So, if we need the legislative intent change, Congress,
But
they sometimes see themselves as the policemen of the United States, but they've turned into the Gestapo.
Shay. Thank you.
if you're ready, so I'll go.
Yeah, please.
If you guys can please take your seats, we're ready to start the second panel, and if anybody's out here that had a seat,
We're selling seats in here to the highest bidder, so
Yeah. Quite a crowd.
yeah. Well, I think this is an area of great interest.
Yeah, it is. That's it.
Okay. Yeah, I think we said it. This hearing will come back to order. We're now joined by Mr. Curtis, or Kurt Spalding. He is the administrator of the Environmental Protection Agency's New England region. And pursuant to the committee rules, if you also would rise to take the oath and raise your right hand. Do you solemnly swear or affirm that the testimony you are about to give will be the truth, the whole truth, and nothing but the truth?
I do.
Let the record indicate the witness answered in the affirmative. Just as the last panel, although you do probably have a prepared statement that's been approved, try to limit it as close as you can to 5 minutes, summarize or skip over a little bit. Your entire statement is going to be placed as matter of record.
I will.
With that, you're recognized.
Thank you. Well, thank you, Mr. Chairman. My name is Kurt Spalding. I'm the administrator of EPA's New England region. I appreciate the opportunity to describe the agency's approaches to the challenges facing Great Bay. I think we all start from a common understanding. The Great Bay estuaries are a real treasure. I've been on the water there with scientists and state officials, and it's easy to see what all who live in the seacoast region already know. Great Bay is a real jewel. It is one of only 28 estuaries in the nation to be included in the Clean Water Act's National Estuaries Program. And thanks to the Piscataqua Region Estuaries Partnership, or PREP, it was referred to earlier, and many other scientific experts, the estuary has been studied extensively for many years. And also, thanks to the stewardship of Senator Gregg, the federal government has made significant investments in research and land conservation in this watershed. Another point of agreement is that Great Bay is in serious decline. In the 2009 PREP study that was referred to, the State of the Estuaries report, showing environmental quality of the estuary was indeed declining. Of the 12 indicators measured, 11 showed negative or cautionary trends. The most pressing problems include discharges from sewage treatment plants, increased stormwater runoff, and non-point source pollution. With mounting evidence of serious decline across the watershed, in 2009, the New Hampshire Department of Environmental Services designated Great Bay waters as impaired for failure to meet applicable water quality standards. The panel before me discussed in detail the scientific uncertainty. What you haven't heard about is the actual weight of evidence. When EPA weighs all the lines of evidence, particularly in the tributary waters where most of the treatment plants discharge, we conclude that there is an abundant evidence of impairment. In New Hampshire, unlike most states, EPA is the Clean Water Act permitting authority. That makes it our responsibility to ensure discharges of pollutants to Great Bay do not cause or contribute to violations of water quality standards. The discharge of nitrogen to Great Bay and its tributaries comes from a variety of sources, including 18 sewage treatment plants in New Hampshire and Maine that discharge close to 20 million gallons a day of wastewater with little or no removal of nitrogen. Beginning to control this resource of nitrogen represents the single most cost-effective and predictable step that can be taken towards meeting water quality standards. Sources other than the sewage treatment plants are also important to Great Bay's nutrient problem, and we will continue to take steps to address these sectors, including the development of a general permit to address stormwater discharges. EPA's initial focus has been on the small number of facilities that discharge the bulk of the nitrogen load coming from sewage treatment plants. The plants in Exeter, Newmarket, Dover, and Rochester account for over 80% of the nitrogen released to the Great Bay sewage from treatment plants. And as is true in every permit we issue, EPA has provided an analysis for the public to examine and critique. In Exeter, Newmarket, and Dover, we've held lengthy public comment periods and heard from proponents and opponents of the proposed nutrient limits. We will document our responses to all comments received and provide a detailed record of our decisions. I anticipate we will make decisions on the permits later this summer. We are very sensitive to the fact that it will take significant public investments to clean up Great Bay. We recognize significant economic impacts facing municipalities for treatment plant upgrades, stormwater requirements, and other municipal needs. We are more than willing to work with communities on implementation schedules designed to minimize the impact to ratepayers. You've heard the coalition propose that EPA take an adaptive management approach to control nitrogen in the estuary that would allow treatment plants to be upgraded on phased schedules. These are the discussions we're having with Newmarket and Exeter now. For 18 years prior to my current position, I was executive director of Save the Bay in Rhode Island. I witnessed the nearly complete crash of Narragansett Bay to nitrogen pollution problems, and we struggled to find solutions, just as the struggle is starting here. I know how hard it is to build a consensus to make the investments in public infrastructure necessary to begin the very long path towards restoring Great Bay. There is still time, but probably not much time, to arrest the decline in Great Bay before it bottoms out. The longer we wait, the harder and more expensive the path back. EPA stands willing to work with each community to find an affordable path to restoring the treasure that is Great Bay. I thank you for the opportunity to testify today. I'm happy to take your questions.
Thank you. Mr. Spalding, during your, from your CV, your previous employment, what was the discharge typical in Rhode Island in parts per milliliter? Or
million?
Million, yes.
Well, the discharges were essentially uncontrolled.
So they
when
were,
we started.
They were hundreds or thousands per.
Do you mean the total?
In other words, where we're trying to achieve 3 or 8, and we're presently
Right.
at 20 or 30.
Yes.
A decade or two ago, uncontrolled could mean 10 or 20 times that.
Well, 40, 50 is not uncommon. I mean, that's basically a fully functioning secondary wastewater plant.
Plus whatever's running off of people's lawns.
Plus what's running off people's lawns, the non-point runoff. The bay I was charged with.
And what did you achieve? What did the water discharge turn into from, at least from the sewage plants? What was it when you left?
Well, there's a set of controls now being implemented on nitrogen.
No, what was it when you left? 18 years ago, what had they, quote, gotten it to?
On nitrogen?
Yes, sir.
On nitrogen. They're still not controlled, so at this point, the bay still
So in Rhode Island, they just put as much crap down as they want.
No, they do not. They now have controls coming online.
Okay, but I asked you
plants.
specifically because
permits in
I want to
place.
try to understand, because the people here want to be as clean as necessary, and they also want to be comparatively taxed, so to speak,
Right.
along with the rest of the country. So using Rhode Island, you're telling me that it wasn't 20 or 30 per, or certainly 8, or certainly 3 when you left, and it isn't today.
There are permit limits in most of the Upper Bay, Rhode Island plants today.
That are higher than being proposed here.
There is a limit of 5 in Providence, a limit of 3 in Woonsocket, a limit of 5 in East Providence.
Okay.
So these limits are very much in the ballpark of what's being proposed
Okay,
here.
well, let's talk about the 5 versus 3. This came out of the earlier panel. Environmental groups like the Conservation Law Foundation, or CLF, have pressed the EPA for stricter nitrogen limits. In the estuary, internal EPA Region 1 email correspondence obtained through FOIA reveals the EPA considered a 5 milligrams per liter nitrogen limit, with CLF, basically an environmental group, not a neutral, just as your previous group was not a neutral, did apparently in this email did not agree. Are you familiar with this email that was delivered by?
I'm not, but I'm familiar with the point that opponents and proponents send emails and make input.
Well, do you know Stephen Silva?
I do know Steve Silva, yes.
And do you know Carl Deloy?
I do know Carl Deloy, yes, both work for me.
Okay, so they're having a discussion about what the standard should be to not get sued, right?
Mm-hmm.
So not getting sued is one of your considerations for setting a standard.
Our standard is that the permit needs to be legal. We get sued on both sides quite frequently. It's a consideration, but not a determination.
Well, but you wouldn't be having these kinds of email discussions if it wasn't trying to get groups to agree. If you meet their standard, you won't get sued. That's what this email shows. It isn't referring to defendable science, a particular study, norms in other areas. It's talking about getting sued.
I think it's important to note that the permit is still under consideration. There's been no final determination. This is a back and forth communication. We again have not made a final call whether it's 3 or 5 or any other number. We propose 3 at this point.
But is this really boiling down to the story of the pound of ground beef, and the way you determine a pound is the butcher's got his thumb on the top, and he's pushing down as hard as he can, and the purchaser has to put his or her thumb on the bottom and push equally hard to get a fair 1 pound of beef? Is it really about who can sue to get the middle ground?
No, it's not.
It certainly looks that way from this email.
The determination by all involved, looking at the weight of evidence, was that 3 was the standard we should propose in the draft.
Well, isn't 3 though the limit of technology? Isn't that essentially you couldn't propose 2 because you couldn't mandate it based on achievable standards?
3, in combination with other factors of non-point and stormwater control, as we all discussed, was discussed earlier, the problem in the watershed and the equity. We believe if these plants do achieve 3 in the future, and other actions are taken, you could meet the water quality standard.
So if they're at 30 and they're willing to go to 8 in a matter of just a few years, why is that not a dramatic improvement where you can make the change, and if I understand correctly from the earlier testimony, in a matter of days after you reach that level of output, you reach that level in the estuary, and then over a season you see the affected change. In other words, isn't it a few days to lower the level and then essentially a season or 2 in order to see the effect?
I wish it was that simple. No. If they go to 8, and in fact we've had conversations with Exeter and Newmarket about a phased approach that would bring them to 8, and then in years follow go to the next level. So in fact, what I was interested in hearing was basic agreement on the phased approach and adaptive management. You go to 8, you'll start to see improvement, yes. there's a lot in these systems. The nitrogen tends to be in the system. It takes some time for it to work its way through.
You know, I'm a native of Cleveland, even though I
Yes.
represent California.
Yes,
I remember when the Great Lakes were dead,
yes,
and they found out they weren't lakes, they were rivers.
right.
Because it took a very short period of time
Yes.
after we quit putting chromate and all
Yep.
these other terrible metals in for it to flush out. Now, in the soils deep beneath Lake Superior and Lake Erie, I'm sure you can still measure some levels that are
Right.
left over from decades and decades ago. But it sounds like this is an area in which you get a fairly quick change. And I guess my question is, phased approach, why wouldn't you, if you will, look for something that is a threefold reduction, or however you want to talk about going from 20 to 30 down to 8, let's just call it an average of 24 down to an average of 8. Why wouldn't you take that and then measure it and recognize that there's no bargain? And I'm not trying to
No, I understand.
pledge a position.
I
I'm
understand
trying
very
to,
well what you're saying.
yeah, but why wouldn't you say, look, we don't have a bargain. We have a point that we agree to go to and then measure. Why wouldn't that be the first 5 to 10? Recognizing that even though there'd be a substantial investment, everybody understands, as I asked the mayor on the first panel, if it doesn't get the job done and science says you have to go further, then in fact there's another round and another round of expense, but you've essentially probably saved a couple of $100 million over that 6, 7, 8 year period that ultimately you're going to use to make the next round of investment if you need to.
Yeah, it's interesting you bring up the phased approach, because indeed what you've just described is a lot of what we've been talking about with Exeter. The only difference is to make a permit based on the science we see today, and there's been a lot of conversation about science from their consultant, but what we see in the science...
And if you noticed, when they were telling me how confident they were, I said, what if?
Yes.
Because we're always confident in our science, and the other side is always
Absolutely.
confident.
And-
I've been in trials,
Yes.
and both sides have experts that absolutely
sure.
agree with them and disagree with each other.
And we have a process for arbitrating that through our Environmental Appeals Board. But the fact is, writing a permit today, we think 3 is what's required, but in discussions about a compliance schedule, we've talked about several years doing exactly what you talked about. Let's put an 8 in, let's look at how it's achieving, and then we would look at the science at that time with the idea that we all need to know how this resource is responding, the issue you just raised.
So let me try to feedback your words, because I think they're very important today, because there may be some misunderstanding of your goal, your likely rule, and in fact what people understand. If in fact their study happens to be right, and yet your belief is the one that ultimately is written on the permit, do we have a situation in which you go to their 8, you measure it, if they appear to be right in hindsight, you don't go to 3, even though you still believe that you should go to 3, but you see that they've achieved? Or is this one of these things where they're guaranteed to have to go to 3, and it's just a question of when?
There are probably 2 permit cycles in play before, and again, talking about the compliance schedule that was being discussed, where we could reconsider that 3 if their science proves right, if other science proves right, or if somebody, and you talked to Peter about the innovation that might be out there, and believe it or not, there's a lot of innovation around this.
I suspected there was, although I didn't get the answer I'd hoped for.
There's a lot of innovation. The state of Massachusetts has just launched a very significant effort that way. But the point is, yes, there is opportunity for reevaluation in the compliance schedule we discussed. I've been discussing with Exeter and Newmarket.
Well, I'm not envisioning a second round, but as you saw in the last round, things come to me.
Yes.
But Mr. Gunta has prepared very much for this, so I'll recognize the gentleman.
Thank you, Mr. Chairman. Thank you, Mr. Spalding, for working with me personally in my office and the communities and trying to find what I hope is a reasonable resolution. We've talked about this over the course of the last year, and I want to try to get as much information from this hearing to the public. I want to continue to digest some additional information that I've heard. As you know, that I have filed legislation to try to find a middle ground in getting to 8 as opposed to 3. But some of the testimony I heard from the first panel did concern me, because it does seem as though some of the communities, I won't say all, but maybe some, feel their voices aren't being heard as much as maybe you would like or you feel they're being heard. And you were in the audience, you heard some of the testimony, particularly from Mr. Rice, on that subject matter. Can you maybe talk a little bit about that? Because I suspect that there is maybe a difference of opinion that you have, or a different approach that you have as the regional director versus the EPA. I mean, I've gotten the sense over the years that you want to try to find common ground, and I appreciate that. But it does seem from some of the testimony that's not the opinion, or that's not what the contiguous communities have been feeling. So can you just talk about that a little bit, and then I'll get into more specific questions?
Well, you make a good point. I took the position, or came in 2009, and this was well underway before I got here. And we have been trying to open up paths of dialogue. I've had regional staff in these communities, especially Exeter, Newmarket, the first 2 permits, many hours of dialogue with those communities on thinking about a compliance schedule that would phase the approach and include this adaptive management that they have proposed. So we have been, and that was something I discussed in depth with my staff, the need to get with the communities and do that. And that's what I used to do running an NGO in Rhode Island, have those kind of discussions. And indeed, 3, 5 other limits were put in without appeals in that place in Rhode Island. So yes, I think the need for dialogue is incredibly important, because things will change. New technology will come forth. Will the population in these towns continue to grow? The real reason this is happening is population growth in this region. So we need to continue to do that.
On that, are you concerned at all about the point that Mr. Rice brought up toward the end of his testimony about sprawl? If I mean, fixing from the EPA's perspective one problem and almost creating another?
The idea that the costs in the cities would go up, people would go elsewhere.
I mean, is that a legitimate issue?
Well, it is a legitimate issue. I think the chairman pointed out that a solution for this region needs to include all the communities. One thing that's very important,
what do you mean?
all the communities that are in the Great Bay Estuary watershed that may be making an impact. So if you have, for example...
Does that go as far west as Candia?
It can. I mean, there needs to be a conversation about that. Those with septic systems and individual systems need to be brought into this. And you might find, as you go up these rivers, that some folks, their septic system may not be working so well anymore. And those problems need to be addressed. What's coming off of farms and lawns needs to be addressed. We're very eager to see a whole watershed solution found. Unfortunately, we don't have that authority. That's state and local authority. So they need to put that program together. If that program comes together and it shows real progress, there could be a reconsideration of everything we've talked about here.
Well, staying on that point for a minute, it seems like the first panel, and I think you would agree, but I don't want to put words in your mouth. So tell me if I'm wrong, but it seems like there's general understanding that roughly 70% of the nitrogen in the estuary does not come from wastewater treatment plant. So you've alluded to that.
There's no disagreement there.
Okay. So should I be concerned with what the communities are bringing to me in terms of their financial concern? If wastewater treatment plant is 30% or 28% of the problem, why is the first phase of modifying or improving this being such a significant financial impact, greater than the 30% that maybe they feel they're responsible for? Because I have to say, I mean, I'm hearing from the communities from day one, they want to fix this problem. They don't want to be in a fight with the EPA. They've encouraged me and asked me to be in this process to try to find that common ground solution, and that's the role that I've tried to play from day one, and that's the role I want to continue to play.
Well, you should be concerned, like I'm concerned. We both should be concerned about impact to ratepayers and how this goes in place, and it needs to be phased. We're working with communities with limits all over, and I mean financial limits all over New England, places like Holyoke and Fitchburg and other places with income levels far below these communities. And we work very hard to phase the work so it does not create undue burden. But the other thing you point out is I think is very important is should the burden be borne by just these communities. In other states, in my region, states put forth some bond issue support and other things. There used to be a grant program that was funded here. I think that's the case in most states. They provide some help for a resource that's a state asset like this. I do regret, I think like we all do, that the federal government can't do more in terms of granting and that sort of thing. But all said, I think we all need to be concerned. Nobody wants to put a community at an unfair disadvantage.
So 2 final points I'd like to make, if I could. So on that note, the Clean Water Act does allow for state legislatures to engage in these particular issues. The first panelist, I think it's been identified that the state legislature has not. So to your point about a greater area, shouldn't the legislature be more engaged, number one? And number two, if the upwards of, could be as 75 million, it could be 164 million, could be 250 million, depending on the requirement of the 3 for the contiguous communities. I mean, I think we probably differ in the cost, but they're telling me anywhere from 160 to 250. Long term it could be $1 billion when you include the other communities. Why wouldn't the adaptive management plan of 8 be sufficient? I hear you say that you want to work with them, but it sounds like you're saying at the end of the day you are saying they have to get to 3.
What I'm saying is
so there's 2 points there.
Looking at the science today, the decline we see in the habitat health of the Great Bay estuaries today, we have proposed 3 milligrams per liter as ultimately necessary to see the Great Bay and its estuaries recover.
However, you've also said that it could change over time.
That said, we have discussed with the communities a compliance schedule that does a phasing approach using the adaptive management approach, that if other means are found to get that nitrogen reduction that all feel is necessary done, that 3 could get reconsidered. We have at least 2 more permit cycles. One thing that is...
When you say permit cycles, how long are they?
They are 5 years, and these permits are overdue. It's one of the issues that is not a good thing, that your permits are overdue. I guess it makes us vulnerable to 60-day notices any time.
So the 3, and the chairman was trying to make this point, and I think it's important for the record, because a lot of people in New Hampshire feel very, very strongly about Great Bay. Some want it cleaned up quicker than others. Some people are more concerned about the financial component. But I think most people would agree we have to get it cleaned up. Getting to that requirement of 3, the email exchange between 2 EPA employees does concern me. I mean, tell me if I should not be concerned. When 2 EPA employees specifically state that either 5 mg per liter with CLF's agreement not to appeal, or 3. That's what concerns me. What is driving, this standard? Is it an agreement with CLF not to sue, or is it what people in my state and these contiguous communities ultimately want to try to come to an agreement with, that it's in the best interest of their community?
Well, I think what you're seeing here is we do look at legal risk related to permits from all sides. Obviously, we're concerned about the communities and their appeals, potentially. That's why we've been meeting with them at length. And then we need to be concerned about appeals from the other side.
So you also meet with CLF?
We, from time to time, meet with CLF, not specifically on a permit like we would with a community.
Have you met with CLF on this? Have any EPA employees?
I don't think they have had a specific conversation about this. I think they've expected CLF to participate like everyone else through the public comment.
Could you within the 5-day period of today's hearing include that an answer to that question?
Absolutely.
Well, my time has expired. I appreciate the chairman's willingness to yield, and I yield back.
Well, you gave us this hearing, so if you need more time, you certainly can have it. As I promised, there'll be something else.
Good.
I worked in engineering for most of my career, but I'm a trained businessman. And so thinking about Sister Peggy's accounting class in college, if I did my math right, if we went from 30 parts to 3 parts, but we're only affecting 30% of the discharge. And the other 70% remains where it is. My arithmetic says that whatever level of discharge you have today, even after they go down by tenfold in some cases, you're still going to have 76% as much flowing into the estuary as you have today. Isn't that roughly right?
I think you're definitely right on your skills.
So, as we're trying to balance what share is borne by 5 communities and what it's necessary to clean this up, if I read correctly, basically you're going to get 70% as much pollution if all 5 communities just ship their water to Tacoma, Washington. So one of our problems here is at 70% the amount of phosphates and nitrogens going into the water, you may still not have a clean estuary. Isn't that true?
Yeah, if no other action's taken, I think your conclusion is correct.
Okay, so as we try to look at our guidance, if you will, for future legislation, including Mr. Gunta's, what I see here is fingers in the dike are good if there's only a few holes. In this case, it looks a little bit like the thing I get my spaghetti dried with. That if these cities comply fully at 8%, then 5%, then 3%, you may still have an estuary that's not able to support what the people in this community and the surrounding 40-some communities want.
That's right, and I'd add to your concern, if population keeps growing as it has been, this action would perhaps have less effect.
So as we're looking at guidance to ourselves, and quite frankly, Senator Shaheen, all of the elected officials that go to Washington, possible guidance to the state for their share, you said that, if you will, these are the folks that are under, and I don't want to say your thumb in an unfair way, but they're under your jurisdiction. The others are effectively not. And would it be fair to say that we need to look to New Hampshire's legislature and ask, and to other communities, what are you going to do to help us with the other 70%?
Absolutely. Absolutely.
Well, let me ask you a rhetorical question. If all of 100% suddenly went to 8%, in other words, all we all know that septic sometimes leak conveniently, and no one addresses them because they're not giving them a problem, but they're flowing right into the water. If all of that was cleaned up, you might in fact have a very healthy estuary at 8 or 10, because you're of course now dealing with 100% of the problem, not just 30. Isn't that true?
You might well. I think there's been a conversation about need for further study. I would presume that would be a good thing to do.
Okay, because part of what we're hoping to do, and Mr. Gunta, as somebody who served here as a city mayor and obviously knows the state, we're looking at providing guidance both ways, guidance to ourselves in our federal role, but also to the state. And you mentioned the cycles. Let me ask just one last question, or last type of question. Mr. Hall, and to a certain extent Mr. Rice, but Mr. Hall particularly, he basically said that your process bypassed an awful lot of requirements of notice and hearings and so on. If that's the case, are you concerned that no matter what number you reach, if you reach a number that one side or the other doesn't have, that it's not defensible under federal law? In other words, you're going to end up in a suit either way?
He was talking about two processes: the process to establish a state water quality standard, and our process to establish a permit on the 3 communities we've issued draft permits for. These are distinct. Most of his criticism was at the state water quality standard process. We feel we followed the procedures to the letter for putting forth these permits. We looked at the narrative water quality standard, not the numeric, the narrative. We looked at the preponderance evidence and came forth with a judgment. Am I concerned? I'm always concerned when someone raises those issues. I think there's ways to arbitrate those issues. He's written a letter to my program, the water program, of course the Inspector General, who we pay very close attention to at EPA.
Our committee does too. It's there are fingers and tentacles.
We stay, as I said, pay very close attention. So those will be, I think, fairly considered about this issue of state water quality standard setting. But on the permit, which is what I'm responsible for, I think we're in a process where public comment is being sought, and then we're going to have to look at it all and issue response to all those comments, and we need to be accountable for the comments we give forth and make a judgment. But again, I have not waited for that. We've been in conversation with community on how to stretch this out to protect their financial health. And we want to continue doing that. In the end of the day, you made the great point. This has to be a whole watershed approach. These permits are just one piece. If that whole watershed approach comes into place, clearly these permits can be looked at again 5 years, 10 years down the line.
Let me ask you one final question. Do you have the authority to work with a schedule that is somewhat closer to what each of these individuals, particularly the mayor, talked about? In other words, they put out bonds for 20 years. They want to amortize all or part of a facility for at least 10 before they tear it down and do it again, recognizing the 1997 facility could potentially become abandoned unless they're able to use it as a base for upgrade. Do you have the authority to work with schedules that would be 10 years before the next step, 5 years before the next step, and so on?
We do. We have schedules like that underway. Most difficult issue, as you can appreciate coming from the Midwest, combined sewer problems. Very challenging. We spread those out. We need to make incremental progress. I think what we're trying to say right now is we have to do something in the short term or move forward on Great Bay, and that's what we're trying to do.
Well, thank you. Gunter, do you have anything else?
If I could have one final comment. To that end, I just want to reiterate for the record that Senator Shaheen, Senator Ayotte, Governor Lynch, and myself have all submitted letters essentially saying the same thing, that we want to support the communities. We hear their concerns. We hear the EPA's concerns. I hear, and we've all heard, the other groups, regional, local groups' concerns. But the four elected people that I mentioned have all asked for and recommended additional time. Mm-hmm. And my hope would be that the AMP is something that is looked at with great optimism and opportunity to find that common ground. Mm-hmm. There are other communities that are affected who I think support the AMP as well. And if there is some opportunity to try to find a way to get to the AMP without the implicit mandate that at some point, without empirical data, getting to that 3, I mean, give them some time to try to assess, if they do the 8, you know, what that would accomplish.
Yeah, we will look at ways to do that. I appreciate the input. Honestly, the input has led us to connect with Portsmouth, and we've discussed actually a final permit there at a draft, but a draft permit there at the 8 milligram per liter level, because they are in a different situation. I want to make sure everyone understands every facility is different.
Oh, yeah, they are.
In the context of this. So we're trying hard to be as flexible as we can. So we will look at that very
And I think there's bipartisan support amongst the delegation and the governor, you know, for that. And I think everyone is trying to balance that the mitigation needs as the community does support, but also the cost approach as well. So I appreciate that consideration.
Thank you. Thank you, Mr. Gunter. I appreciate your bringing this to our attention and bringing us up here. I want to note that the food, the accommodation were excellent. The weather, so-so. I also
thank you for visiting the region.
Well, that's what field hearings are for. If we stay in Washington and ask you to come, we get one selection. For all the men and women who came here, hopefully this was an opportunity for you to see what you would otherwise not necessarily have been able to see in Washington. So I want to thank you for your patience and your participation. We stand adjourned. There you go.